Yesterday, the Massachusetts Supreme Judicial Court came out with its opinion in the Karen Read double jeopardy appeal. And in that opinion, they laid out the reasons why they are denying her claim of double jeopardy. And therefore, the second trial is going to go as scheduled. Now, yesterday, we did an entire video breaking down a lot of different parts of that opinion and the different issues that I have with that opinion. But today, we are really going to concentrate on just one very, very important issue, which I think this opinion could be changing completely Rule 27, specifically Rule 27B. So in order to really understand this, I want to kind of walk you through what exactly they're doing with Rule 27B. So first, what we'll do is we'll pull up Rule 27. We'll go through it very carefully and understand everything, and then I'll show you how this opinion seems to be completely changing Rule 27 going forward. So here we go. Let's pull up Rule 27. Here we go. This is, as you see from the top, Massachusetts Criminal Procedure Rule 27 verdict. Okay, so here we go. And this is how it starts. A return. So it starts off with returning a verdict. The verdict shall be unanimous. It shall be a general verdict. And put general, that term, in your back pocket for now, because we are going to have to define all these terms, but don't worry, in good time. It shall be a general verdict returned by the jury to the judge in open court. The jury shall file a verdict slip with the clerk upon the return of the verdict. Now 27B. And 27B is where all the fun begins, because 27B is the rule that allows a judge, it's permissive, it allows a judge to ask for partial verdicts. So let's take a look at this rule carefully, and we'll see how broad and wide open it is. If there are two or more offenses or defendants. So are there two defendants in this case? No. Are there two offenses? Are there two charges in this case? Well, yeah, there's three. Okay, so this rule would apply. If there are two or more offenses or defendants tried together, the jury may, with the consent of the judge, at any time during its deliberations, return, that's also another important word which we're going to have to define soon, return or be required by the judge to return a verdict or verdicts with respect to the defendants or charges, and why they changed from offenses to charges is a good question, but let's not nitpick here. The defendants or charges as to which a verdict has been reached, and thereafter the jury may, in the discretion of the judge, resume deliberation. The judge may declare a mistrial as to any charges upon which the jury cannot agree upon a verdict, provided, however, that the judge may first require the jury to return verdicts on those charges upon which the jury can agree, and direct that such a verdicts be received and recorded. So here we go, 27B, which again, it's very clear that it's permissive. It's not required. No judge is required to ask for partial verdicts. It's all 100% permissive, but there it is, in a case where there's two or more charges. And in this case, in Karen Read's case, definitely there was two or more charges. Now, why is this important? The reason why this is important is that the way that the Supreme Judicial Court analyzed this issue was under manifest necessity, which, if you know anything about this channel and know anything about my opinion, I think that was a mistake, because really the analysis ends by whether the defense objected and whether they therefore consented to the mistrial. Okay, but that's a different issue, which I've spoken about before. I spoke about yesterday. At the end of the day, the Massachusetts Supreme Court is analyzing this under manifest necessity. Under manifest necessity, one of the requirements for the judge to order a mistrial or declare a mistrial based on manifest necessity is that the judge had to give careful consideration to alternatives to a mistrial. And 27B seems to suggest that there is an alternative available. Now, no one's saying that Judge Cannoni is required to ask for partial verdicts, but because it is an option, it's an alternative. And it's an alternative that she could have, if she was doing this right, what she could have considered before declaring a mistrial. So does that mean, the fact that she did not do this, does that mean that she could not have declared a mistrial appropriately? It's improper because she didn't carefully consider other options, other alternatives. So this was the argument that Karen Read's side made when it came to manifest necessity. So this is what the opinion of the court has to address. This is what it has to address, whether this 27B is a reasonable alternative. Okay, so before we get into the opinion, though, I want to show you the decision in Roth as it relates to 27b. Because Roth is the first court that I'm aware of, and Roth is the court that this opinion definitely relies very heavily on. Roth chipped away a little bit at 27b. They're the first court that said, you know what, this is not as wide open as you think it is. Not in every single case is the judge permitted to ask for partial verdicts. So to understand Roth, we have to understand the difference between being charged with different charges, 1, 2, and 3, charged with one charge, a second charge, and a third charge, and then being charged with one offense, but that offense carries with it lesser included. There's a very important distinction. Now, the Roth case very clearly was talking about a case where the judge asked for partial verdicts for lesser included. So there's actually, I think, 2 charges in that case, but the judge was asking for partial verdicts as it relates to the lesser included of a charge. So the jury came back, they were hung on both charges. The judge said, what about the lesser included? Did you agree on any of the lesser included? Can I take a partial verdict on the lesser included? And that was the issue that Roth dealt with. Okay, so we're going to see why or how the opinion in this case, in the Karen Read case, how they try to use some of that logic and whether that's actually a good analysis or not. But before we jump into that, I want to show you what their analysis is in terms of partial verdicts when it comes to lesser included, because I think it's very interesting and it really kind of sets the stage. So here's Commonwealth versus Roth. It's a long opinion. You can read the entire thing, but this is the important part. This is what it says. Where the jury have reached verdicts on some but not all charges, Rule 27b provides that the judge may require the jury to return a verdict or verdicts with respect to the defendants or charges as to which a verdict has been reached. We just read this rule for you. But what does it mean, return? The judge may require the jury to return. What's a return? Well, a return, however, requires a general verdict. So if you want to know what a return is? A return is a general verdict. You know how they know that? Because that's exactly what 27a is, return. The verdict shall be unanimous. It shall be a general verdict. So return, what does return mean? Return means a general verdict. It's right there in the rule. Okay, so when you go to 27b and you read return, you read deliberations return, then, and also required by the judge to return a verdict, that just, you go back to 27a to understand what that means, and then you go to 27a, it says a general verdict. Well, what's a general verdict? Okay, how's that helping us? Now we're going on a wild goose chase. Return means general. What does general mean? Well, guess what? The Commonwealth versus Roth case explains what that also means. A return, however, requires a general verdict. The term general verdict refers to a verdict dispositive of the entire charge, not just a portion of the charge. So, what is a general verdict? The entire charge. The entire charge, not a lesser included, because lesser included is not an entire charge. An entire charge is the entire charge. So, a judge is only permitted to ask for partial verdicts on entire charges. And why this is so important is because what Roth is doing here is really, they're saying this is right out in the rule. It's straight out in the rule. You just have to understand how to read this all. Right? 27b looks wide open, but it's really not, because if you actually understand what return means, which means general, and general means an entire charge, then really directly in the rule of 27, it really states explicitly, you just have to know how to read it. It states that you cannot get a partial verdict on lesser included. So it's really directly right there in the rule. Okay, so that's the first part of Roth that's important to understand. So Roth is not really creating this whole new limitation on 27b. It's really right in there in the words itself. You just have to understand what the words mean. Yeah, the case law explains what the words is, but it's really directly right in there. And therefore you can say, okay, this is already part of the rule. Now we're going to see whether this stays true for what this decision is trying to do, the Karen Read decision. Okay, so really, again, all Roth is doing is saying that when it comes to lesser included, then we're not allowed, the judge is not allowed to ask for partial verdicts. Now let's go to the opinion in the Karen Read case, okay? And we're just going to concentrate on on the part. Let's just get back up to there on the part that we're talking about today. Okay, we're not going to go through the entire opinion again. All right. So the first part of what they're trying to do is that we have to just understand what they're tasked with. What they're trying to do is they're using a Fuentes type of way of analysis, which we explained in the last video. We're not going to get into the details of this, but what they're doing is they're trying to look back in hindsight and saying, is this a reasonable alternative in the first place? Is it a reasonable alternative for Judge Cannoni to have asked the jury for a partial verdict? So here they start off the following. Here, the jury were instructed on 3 separate indictments, along with 2 lesser included offenses on count 2. But the trial record offers no indication that a partial verdict was imminent or possible. And this is what they spend a lot of time on now, next page and a half about whether the notes themselves had any sort of indication that there was some sort of consensus amongst the jurors on any of the charges. Like if they give you a little bit of a hint in the notes, then hey, maybe the judge should ask for partial verdicts. But here what they're saying is that the notes did not indicate any sort of consensus amongst the jurors. But let's just stop right there for a second. So what is the court trying to say now? Is the court trying to say that therefore the judge would not be permitted to ask for a partial verdict, just like by lesser included, where the judge is not permitted to? Is that what they're suggesting here is? Is that what their argument is? That Judge Cannoni is not permitted to because there's no indication in the notes? Or they're just saying, look, I mean, there's no indication in the notes. Okay, so what? Who cares if there's no indication in the notes? It's still a reasonable alternative that you could have thought about. You're right. You could have had the conversation. Alan Jackson, David Yannetti, Adam Lally. We know that the notes do not have any sort of indication that there's any sort of consensus on any of the charges. Is this still an option? Is it still an option for me to ask for a partial verdict? Like they could have definitely had that discussion. She's not barred from asking. So then why does it make it not a reasonable alternative? It's definitely an option and it should have been considered. So I don't know exactly what they're trying to do. Are they trying to say, is this opinion trying to say that if there's no indication in the notes at all of any sort of consensus, then the judge is not allowed to ask for a partial verdict? Is that what they're suggesting here? Because that would be a completely new Rule 27B, which appears nowhere in the rules. You can't read that in the rule anywhere. The rule is very wide open. A judge is permitted to take partial verdicts. Doesn't say anything in there about any notes, that the notes have to indicate that, or that there's some sort of indication of consensus. It just says that the judge is permitted to do that. So once the judge is permitted to do that, not that the judge has to, but once that the judge is permitted to do that, so then it's a reasonable alternative, and it should have been considered before declaring a mistrial, right? Okay, but this is their first part, and this is the first issue that I have with it. That I don't know why they're talking about this. Are they trying to read in a new limitation now to 27B? That 27B is only when there's some sort of indication of consensus. And again, then I said they go on like this for a little while, and they say, in short, the record before the trial judge suggested complete deadlock. The first and second notes provided no indication of a partial consensus, and the third note plainly implied the opposite. Okay, so what? So what? Does that mean that it's not an option? Maybe they actually have a consensus and didn't put it in the notes. Is that a possibility? Sure, it's a possibility. Then maybe they were confused, as we're getting reports now that they were. So if that's the case, so then it's still an option. It's still an alternative. And therefore, it could have been considered and should have been considered before declaring a mistrial. Okay, so that I don't think that really helps at all. And I don't know what they're trying to say. Are they trying to now read a new limitation into 27B that doesn't appear? So that's number one. But now let's move on to the more, what I would say, more a bigger stretch. Okay, this is where it gets a little bit interesting. They're quoting Roth. And again, like I said, they rely heavily on Roth throughout this entire opinion. Now, Roth, as I said, has to do with lesser included. And also, I think that the fact pattern in Roth is important to know as well, as we're going to soon see. Because they do quote from Roth, but they're kind of picking and choosing what they're quoting. Because again, Roth really, as we just said before, stated very clearly that really in the rule itself, it says that a judge is not allowed to ask for partial verdicts when there are lesser included. That is straight out in the Rule 27B. That's what return means. Return means general. General means an entire charge. And that's it. That's the end of the game, really. but they continue talking about what happened in that case. That's what the opinions generally do, and that's what they did in Roth. They didn't just stop it at that quote that I showed you before. So they continued with it, and now that's the type of analysis that this court is going to try to borrow and use for the Karen Read case. All right, so listen to this. Now we know that the risk of coercion is a problem. That is, you have to be very careful with. You don't want to coerce the jury into giving you a decision. You want it to be natural. You want it to be there freely given, and they had these discussions, and this was what their verdict was. So listen to what they say here. In this case, the risks of coercion were evident. After receiving the third note, the judge was statutorily barred from ordering further deliberation without the jury's consent. So the rule is in Massachusetts that after you give a Tui Rodriguez charge and the jury comes back with another note, the judge is not allowed to send them back for further deliberations unless the jury consents. The jury says, we don't mind going back for deliberation. All right, they're allowed to. But the judge cannot say, I'm ordering you back to deliberation. The judge is not allowed to do that. Statutorily barred. There's a statute. They're not allowed to do it. So now everybody knows that. Okay, the judge is statutorily barred from ordering them for further deliberations. So asking jurors whether they would nonetheless consent to further deliberation would have implicitly pressured them to compromise those beliefs in order to salvage some part of the trial. In these circumstances, there is simply too great a risk that any resulting verdict would merely be the product of one hasty final attempt to satisfy the judge's apparent desire for some form of decision on the case. And that's a direct quote from Roth. And that we're going to get into Roth in 1 second. And if the judge were to inquire about the possibility of a partial verdict, and now they're putting these quotes in. So this first part, and if the judge were to inquire about the possibility of a partial verdict, that's them talking, this opinion talking. And now they're going to bring this quote from Roth. By definition, any further discussion amongst the jurors regarding their response to the judge's partial verdict inquiry would itself be further deliberation violation of the statute. So, if you are going to ask for partial verdicts, what it seems to be that this opinion is saying, and they're basing it on Roth, that by asking the jury for partial verdicts, that means that that's going to require discussion. That's going to require discussion. That's going to require deliberation. And you're not allowed to ask for deliberations anymore. You're statutorily barred as the judge from asking for further deliberations, right? There was a Tui Rodriguez charge in that case as well. And they're asking for partial verdicts. Well, that is, you're not allowed. You're not allowed to continue. You're not allowed to tell the jury that you need them to discuss the case more or deliberate more. Okay. Now, before we get into why that's even true, why there has to be any sort of deliberation, let's just see actually what the Roth case says. Okay. And what happened in the Roth case, because there it was very, very different, as you're going to soon see. Okay. So this is the quote that we were about earlier. And now let's go down to the quote that they're quoting here. And we're going to see exactly what they left out from this quote. This is what they're quoting. Okay. This is what the Karen Read opinion is quoting. And I'm reading from you the Roth opinion. So this is the Roth opinion, and they're using parts of this as they're quoting. Here we go. While technically inquiring only as to what the juries have already agreed on, the request for partial verdicts broken down by lesser included offenses, which is the number one distinction between Roth and the Karen Read case, but they don't care about that anyway, implicitly suggests that the jurors should try just a bit harder to come back with at least a partial decision to show for all their efforts. And by definition, any further discussion amongst the jurors regarding the response to the judge's partial verdict inquiry would itself be further deliberations violation of the statute. So this is all part of their thought process. They're not saying, I believe, that automatically when you ask for a partial verdict, that is automatically going to require further discussion. They're saying, by definition, if there would be any further discussion, then that would be in violation of the statute. And then continue with what they're saying here. Indeed, as was done here, okay, as was done in the Roth case, and you can go ahead and read the entire case, and you'll see how things were extremely different than what they were asking the judge Canoni to do in this case. Indeed, as was done here, meaning in the Roth case, each time the jury were sent back to record the unanimous vote, starting with the offenses as charged, the judge gave the jurors the option of reporting back that the defendant was guilty i.e., he gave them the option of reaching an entire verdict, notwithstanding their twice having reported a deadlock. So what happened in Roth actually was that after the Tweed Rodriguez charge was read and he asked for partial verdicts, when he sent them back to the jury room, he said, you know what? You guys can come back with any verdict that you want. You can come back with a verdict on any charge, not just your partial verdicts. Well, hold on a second. Hold on. That certainly sounds like you're sending them back for deliberations. You're not just telling them to go back into the room and just come back with your partial verdicts. That's not what happened in Roth. He was saying you can come back with whatever you want, any verdict that you want on anything. Well, that seems to suggest that you can be also deliberate. Well, you can't deliberate because the statute said you're not allowed to deliberate. So that's the problem. That's why it's extremely different. Roth, what happened in Roth than what happened in the Karen, what they were asking to happen in the Karen Read case. All they're asking in the Karen Read case is that Judge Cannoni could have asked the jury as they're sitting there, do you have any partial verdicts? It's a yes or no. Do you all agree on anything at all? Any of these charges, 1, 2, or 3? Don't get into the lesser included. I'll let ask that. But charge 1, 2, and 3. That's not going to require any sort of deliberation. That's not going to require any sort of discussion. It's just an answer, yes or no. You pull the jury, and that's it. Their job is done. But that's not what happened in Roth. Roth, they were sent back to the jury room. That certainly looks like a deliberation. So that's the important difference here. Okay? So when we go back to the opinion, and we see here that, indeed, if the judge had inquired about a partial verdict on her own initiative, and the jury returned a verdict of guilty on any of the counts, there is no question that this defendant would be making a strenuous and potentially meritorious argument that the guilty verdict was the product of coercive intrusion into the function of the jury. So now they're quoting from Roth and trying to inject it into what happened in the Karen Read case. So, thus, given the entire course of the jury deliberations and the empathetic language of the third note, the jurors were deadlocked on the charges and that further deliberations would be coercive, the judge acted within her discretion in declaring a mistrial without inquiring sua sponte about a partial verdict. So what they're trying to say from this Roth case, and this is what my understanding from this case is, that they're trying to say that there was no option. There was no option. Remember, part of an abuse of discretion when it comes to manifest necessity is, did the judge consider alternatives? Were there any alternatives for the judge to consider? And the defense is arguing, yes, partial verdicts. Well, here they're saying, well, there's 2 reasons why the judge could not have considered partial verdicts. And remember, because they have to say that the judge could not have considered this. Because if the judge could have considered it, well, then that is a alternative. So therefore, they have to kind of wrap this up in a way that there's no alternative here. And number one, they're saying the notes did not have any indication that there was consensus on any of the charges. Okay, we spoke about that. Number 2 is that it would be too coercive. It would be too coercive. Why? Because Roth says that this idea is coercive. No, Roth doesn't say it's coercive. It would be coercive if it would require more deliberations, like what happened in Roth. And then the only other logical reason here that they're saying is that, well, by asking for partial verdicts, that's going to require a discussion amongst the jury. If it's going to require a discussion amongst the jury, that means it's requiring deliberations. If requiring deliberations, that's statutorily barred. You're not allowed to do that as a judge. So if they are suggesting by this opinion that after a Tui Rodriguez charge is read, you cannot ask for partial verdicts because that's going to require deliberations, which is what they're trying to pull from Roth, well then now 27B only applies when a Tui Rodriguez charge was not read. That is what they're doing to 27B now. That 27B is only, now, I don't know what you want to do with the first part of the opinion. Maybe 27B is only when there is some sort of indication in the notes. I'm not sure if they're suggesting that, but you can definitely read into this opinion that they are. But even if you want to say, nah, they're just kind of mentioning that. That's not really what they really are hanging their hat on. Why it's not an alternative. Maybe they'll buy all my arguments. So what about this part? This part when they're saying that any sort of question after Tui Rodriguez is too coercive. It's too coercive, and then it's going to be like you're requiring more discussions, more deliberations. And if that's what you're requiring, you can't do that. You're statutorily barred. Well, then you're completely changing 27B. And you're saying that 27B only applies before a Tui Rodriguez is read. Is that what you're doing now to 27B? And if you're not doing that to 27B, if you're not saying that you cannot ask, if you're not saying we are making a new rule now that after a Tui Rodriguez charge is being read, a judge is not allowed to ask anymore. Just like in Roth, you're not allowed to ask because of lesser included. So too, we're making a new rule now that after Tui Rodriguez, you're not allowed to ask after Tui Rodriguez. So then, number one, you're completely changing 27B. If you're not saying that, if you're saying, no, we're not saying that the judge is not allowed to ask. The judge is still allowed to ask. Well, if the judge is allowed to ask, well, then why isn't that an alternative? If it's an alternative, then the law requires the judge to consider. Now, the judge doesn't have to consider all alternatives. That's true. But what they're trying to do is they're trying to say that wasn't a reasonable alternative. But I don't see why not. It still can be an alternative. So that's, again, one of the issues that I have with this opinion. So I just wanted to make this clear because I think this can have extreme broad implications and ramifications for all practicing attorneys in Massachusetts. Anytime that they're going to be asking for partial verdicts now, are they going to be barred from asking because of if a Tui Rodriguez was read already? That's the question that you have to ask, and that's what you have to figure out if this opinion is saying. So those are just my thoughts about that specific part of the opinion. I think that there's some other issues with the opinion, which I explained in my previous video. It's just an hour long, so you got to sit through it, but there's a lot of very interesting things about that opinion. So that's going to be it for now, at least on this thing. There's some other motions that were filed today in the Karen Read case, and hopefully we'll get to that also as well. We'll put out a video about that. So that's going to be it for now. Please, if you haven't yet, subscribe, like, and we will see you next time.